So we are going to use few minutes to discuss this one, renewal of leases. Renewal of leases. Renewal of leases. So please pay attention whilst we go through this. We have maximum of I think maximum of 20 slides, which is going to be a very quick one. So make sure to pay attention whilst we go through this. Renewal of leases. Renewal of leases. When you talk about leases, we are talking about an interest in land for a duration which is certain or capable of being ascertained. You go for a land. I remember when I was doing accounting, we did what is called financial lease, and then the rest, operative, and then financial. So when you talk about leases, when you are moving in town and then you see a bank operating in a particular bank, building, or Barclays or Fidelity operating in someone's building, then your attention should quickly shift to leases, an interest in land. You go for an interest in land for a duration, and that duration is certain or capable of being ascertained. So basically, it arises when a person who holds an allodial title or customary law freehold or common law freehold or usufructuary interest conveys the interest in the building or in the land to another person. So that is how it is being created. We will go into it. We'll go into it, giving reference to section 6. We'll go into it. So we are looking at renewal of leases. Renewal of leases. So that is what we are looking at. Renewal of leases. What is our objective? By the end of the lesson or by the end of the discussion, you should be able to discuss how leases were renewed before Act 1036 and how leases are renewed after Act 1036. So this one also could even be some of the changes that the Land Act has brought. This one alone is also another issue, which is a changes that the Land Act has introduced. Because before it was done some way, after it is done some way. So it is part of the changes that the Land Act has also introduced. So that is our objective for today. That is our objective for today. And then, as I keep on saying, we have to pay respect to the Land Act. So within the next 10 seconds, let us pay respect to the Land Act. We are being silent for the Land Act because it has done us much good than harm. Act 1036. All right. So we have paid our respect to the Land Act because it has done us much good than harm. So quickly, we are going to section 6. Section 6. Section 6. Section 6. Mr. Aubrey, are you there? Section 6. Section 6.
Yes, sir. Section 6 of the Land Act. That's a leasehold interest.
Section 6, right?
Yes, please.
Let me project it so that others also could watch it. Let's go.
Yes. A lease, A, is an interest in land for a duration which is certain or capable of being ascertained. B, arises when a person who holds an allodial title, customary law,
Please,
freehold.
Please, forgive me, I had an issue.
Hello. Hello.
Yes, I'm listening, please. A lease. Section
Okay.
6.
Section 6, leasehold interest. A
Good.
lease, A, is an interest in land for a duration which is certain or capable of being ascertained. B,
Okay.
arises. Can I continue, please?
Yes, please. Okay. So you want me to explain?
Okay.
Okay, all right. So when you say a lease is an interest in land, you are saying that interest in land is for a duration. If you say allodial title is not for a duration. If you are allodial title holder, it is not for a duration. If you're usufructuary interest, it's not for a duration. But lease is for a duration. Yes, we have granted you the interest in the land, but it's for a duration. It is for a duration. So some of the characteristics of a lease is that lease is for a duration. And then that duration could be ascertained 20 years, 40 years, 50 years. Well, if you like, you can go to banks. You can go to Fidelity Bank and ask them the building you are renting, the building you are leasing. That's sometimes we just say rent. But it's lease. The building you are leasing. How many years are you going to stay here? They will be able to tell you. So that is how I think it is very loud. That one very clear. Let's move on.
Yes. B, arises when a person who holds an allodial title, customary law freehold, common law
Leases.
freehold.
The leases as a contract or leases and as agreement is created when someone who holds a allodial title subject to section 2, customary law subject to section 3, common law subject to section 4, or usufructuary interest subject to section 5 conveys to another person an interest in land for a specific term subject to terms and conditions. So these people, these guys, allodial title holder, customary law freeholder, common law freeholder, usufructuarist, or whatsoever, they convey, they decide, they are the ones who are holding it. The interest belongs to them. Then they are saying that, well, it belongs to me. I'm letting you have a feel of it for some time, for 20 years, for 10 years, for 5 years. That is what brings in what is called lease, a lease. And then the person who has taken it as a lessor, a lessee, the person who is giving, the allodial title holder who is giving, the customary law freeholder who is giving, the common law freeholder who is giving, the usufructuarist who is giving, is called a lessor. Lessor. L-E-S-S-O-R. L-E-S-S-O-R. Lessor. And then the person who is receiving, C, I normally use E, receiving, receiving, it's called lessee. Receiving, lessee. The person who is receiving, lessee. Giver, giver, lessor, giver, lessor. So the one who is receiving is called lessee. The one who is giving is called lessor. So don't go and say giving, taking. No. Use the legal terms. Lessor, lessee. So it arises when a person who holds allodial titles. So it is only these guys, these holders, allodial title holder, customary law freeholder, common law freeholder, usufructuaries, they are the ones who could lease out. If you are not part, so he alone will let you get a lot. You begin with it by saying that you begin with the question by defining what a lease means. You see that the question is about renewal of leases, but you don't go straight to renewal of leases. No. You tackle this one a bit. You talk about leases a bit. You bring out something. You let us know that it is for a duration. And that duration is capable of being ascertained. Being ascertained means we can know, we can value, we can measure the duration. And then it is only being created from a allodial title, the customary law, the list that I've mentioned here. And then C. Aubrey, C.
Yeah, C. May, in the case of a sublease or an assignment, arise when the holder of a leasehold interest grants a sublease out of that interest or assigns that interest.
This one,
And
I think
D.
I've told you. Wait, I think this one I've told you before. I told you that you're not supposed to be chewing and pouring this. Understand it. So simple. So simple. See, it's so simple. Listen to me carefully. See, it's so simple. Now, I have gone for a lease. So now I'm a lessee. If I'm a lessee, it means that I'm holding a leasehold interest. Don't forget. I'm holding a leasehold interest. Don't forget. I am holding a leasehold interest. Don't forget. Oh, don't forget. Now, me, who is holding a leasehold interest, under this regard, I am the bank of possible. Probably I've gone for a building of which I'm using it for my operations. And then I'm the bank of possible. So I'm having a leasehold interest in the building of, let me say, Aubrey, in the building of Mr. Aubrey. So I'm having a leasehold interest in the building of Mr. Aubrey. Now, remember, according to A says that an interest in land for a duration. So it means that the leasehold interest that I'm having in the building of Mr. Aubrey is for a duration. Don't forget, the A also says that which is certain or capable of being ascertained. So it means that the number of years should be able to be measured. We should be able to measure it. So I'm holding a leasehold interest for a duration of 20 years in the building of Mr. Aubrey. Granted. Now, assuming that possibly possible, I no longer want to operate in the building of Mr. Aubrey because possibly my technical team have been able to come up with a better place, a better option, possibly at East Legon. So they want me to establish the business at East Legon, but not at, let me say, Kaswa or Wager. And then I know I'm no longer in need of the building of Mr. Aubrey, though I'm having a leasehold interest in that building. I can decide to give the building to someone else. Yes, without even consulting the person who gave me the land, because I hold leasehold interest, except that within the contract, it was being stated that before you could lease it out, you have to come for my notice. Other than that, I am not obliged to go to Mr. Aubrey that, oh, I entered into a leasehold interest or agreement with you. So, Mr. Aubrey, I want to give it out, so give me permission. No. So if I am giving it out to different person, I am subleasing, please, or I am assigning. Two ways. I'm coming to explain them. If I'm giving it out to someone, I am either subleasing or I am assigning. What therefore does the subleasing mean? And what therefore does the assignment mean? I am subleasing when and if the 20 years leasehold interest I have, I am giving the person years or a duration which is less than the 20 years. So I hold 20 years leasehold interest in the building of Aubrey, Mr. Aubrey. If I am giving out any years, if I'm giving out any years, if I'm giving out any years or any year which is lower than the 20 years, then I am subleasing. But if I'm giving the whole 20 years to the person, then I am assigning. the entire 20 years. You are assigning the 20 years to someone. But if you are giving any years below than the 20 years, it's subleasing. Fair deal. Now D. Okay, the D. Does not exhaust the interest of the grantor in the land. So it means that the interest of the grantor, the person, the lessor, we are not exhausting it. We just came for a leasehold something. So when the time is due, we will leave. All right. So quickly, let us enter into it. Before the Land Act, what was the position? Before the Land Act. Don't forget that the Land Act came into force in the year 2020. If my memory could set me right, I think it was 23rd December 2020. Yes, 23rd December 2020, the date of assent. The date of assent. So 2020, but before 2020, there was a judgment. There was a judgment that was being passed by Supreme Court in 2011. In the case of Mreku and others versus Tete and another. 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 So the holding of the court was that the court declared that if there is no renewal clause in the lease, that the lessee, don't forget, lessee is the one who received the lease. In this case, I am the lessee. Mr. Aubrey, who gave me the building, is the lessor, so lessee. So the Supreme Court declared that if there is no renewal clause in the lease, that the lessee can exercise, the one who received the lease can exercise. He must relinquish, he must hand over or surrender control of the land to the lessor at the lease termination. So before the Land Act, the position was that if I enter into a lease agreement, in this case with Mr. Aubrey, supposedly I am into this agreement with him, so I have leasehold interest in his building. But when we were entering into the agreement, we didn't conclude on how the agreement will be renewed when the one we have entered into elapses or when the time is due. You see, sometimes it happens when you are in a building, when you rent a building, you let the landlord get to know that, yes, when it is almost 2 months to the time, I'll come and see you and then we talk about it. And then, so the leases, if there is no renewal clause that when the leases is over or the lease contract or agreement is over, this is how it is going to be renewed. If there is no renewal clauses, then the position of the court is that the lessee, the person who came for the lease, in this case, myself, I must hand over the building and go. No matter what I've done, I must hand over and go. So this position was very harsh. It was very harsh in the sense that if I have taken a lease for 15 years and I've done a whole lot of things on it, remember that leases, mostly the duration are for a longer period, some 30 years, some 50 years, some 25 years, some 20 years. So you can do capital projects on it. And then you go and sleep, you wake up early in the morning, and then the date, the 25 years or the 20 years is up. And they are saying that whatsoever you did on the land, leave it and go. I should just leave it and go, just like that. So the position of the law was too harsh. It was too harsh until the promulgation of the Land Act. So this position of the law was...
This is one of the changes that has also occurred, right?
I will let you come in, please. So let me go a little bit further. Forgive me. I will let you come in. For the benefit of those who couldn't come, I want to record a little bit for them. So this position of the law was extensively criticized as unfair, given that many leases had many lessees, those who have gone for the land. Many lessees had invested considerably in structuring their leases before the Supreme Court's judgment. Again, it was being realized that people had also invested in projects. They have invested in projects because they think that, oh, for the lease is there. Oh, okay. Oh, the lease is there. I have 40 years. I have 20 years. So I have to even build a house on it and sleep in it, or construct something good on it. And then all these people in Ghana have done this. Some did it in the year 1970. Some did it in 1980. Some did it in 1990. Some did it in the year 2000. And then 2011, Supreme Court, you are passing this judgment. So it means that then the whole Ghana, when leases contracts are over, no lessor, I mean the owners of the land, or the owners of the land, no lessor is going to renew leases again, because now they are coming to get properties. Lessors are coming to get properties. We are not going to renew it again. If this is the position of the Supreme Court, the critique here is that now when all leases are over, we are not going to renew it again. We are going to get property. Lessor. One day I'm coming to become landlord, but I've never bought cement. I'm coming to become landlord, but I've never bought cement. I'm coming to become, I'm becoming a millionaire overnight. Because the law says that when there is no clause in it, the implied term is that the parties did not agree for the leasehold interest to continue. So leave, vacate my land and go. Vacate my land and go. So if that be the case, then the lessees are going to suffer. So at the end of the lease, the lessor will receive possession of the land and all of the investments that is made on it, which was deemed unrealistic and unfair. This issue could be exacerbated if the lessor objects to or refuses to renew the lease when it expires. Yes, indeed. I've gotten to know that, yes, because of that, the lessor will not decide to renew the contract so that he can get the property. So what was the position of the Land Act? Before then, ask your question. And then after the Land Act, the renewal, what it has done, we enter into it. Yes, please. Oh, okay. Okay. I think we can continue. The person is not here. I think the line has dropped. So we can continue. So after the Land Act 1036, there are 4 changes that has been made, that has been introduced by the Land Act. 4 changes that has been introduced by the Land Act. The framers of the Land Act, they really did a great job, very fantastic job. So the Land Act 2020 at 1036 has changed the law's position on renewal of leases upon their expiration. These are bare land leased to indigents. When we talk about bare land that nothing is on it, that has been leased to indigents, people of a particular locality. So where you are staying, people who are from there, you give your land to them. So bare land leased to indigents. Then we have bare land leased to non-indigents, but they are citizens of Ghana. They are non-indigents, but they are citizens of Ghana. And your locality there, you have leased your land to a person, but the person, if you are an Akan, the person is a Votarian. If you are an Akan, the person is a northerner, but the person is a Ghanaian. So bare land leased to non-indigenous citizens of Ghana. And then number 3, leases of bare public land to citizens by the state. Leases of bare public land. Bare public land. Remember, here is public land to citizens by the state. So it means that it's the state that is giving public land to citizens. The state, sometimes the state can do that. We were having housing there and then state agency. That's a state building, something there. So the state could also give out a land and take money. And then we have leases to non-Ghanaians by Ghanaians. A Ghanaian who is giving a lease to a non-Ghanaian, probably Chinese, have come to Ghana and then they want a land, and then a Ghanaian is leasing out the land to them. So these are going to be discussed seriatim. But before then, let me give you a hint that will help you to be able to remember this. Use the word pin, P-I-N-G, pin, pin, P-I-N-G. Use the word pin, pin. That is what I use to learn law. It helps me a lot. Pin. So whereby the P stand for lease of bare land, lease of bare public land to citizens by the state. So it's public land to citizens by the state. P stands for public land to citizens by the state. You give the public land to citizens by the state. P. I stand for indigens. So bare land leads to indigens. Indigens. The land has been given to indigens. The next one is N. Bare land leads to non-indigens. Non-indigens. N. Non-indigens. Non-indigent citizens of Ghana. Non-indigent. And then the last one is G. Ghanaians to non-Ghanaians. Leases by Ghanaians to non-Ghanaians. So PIN. Use PIN. P-I-N-G. PIN. It will help you. P stand for public. I stand for indigens. N stand for non-indigens. G stand for Ghanaians. However, I'm going to discuss them based on what I've listed here. It doesn't mean that they are in order, but that is what will help me to be able to present it very well and laudable. However, for you to be able to recall, you can use the one that I use, red indication, this part, to do it. So I'm going to set the ball rolling. I'll be done very soon. Now, number 1 is bare land leased to indigens. When a bare land is being leased to an indigent, a bare land is being leased to an indigent. You're saying that where bare land is leased out, where bare land is leased out by an allodial or usufructuary interest holder to a person who happens to be an indigent of the area where the land is situated, the lease is subject to automatic renewal of the lease, provided such a lease has developed, provided such a lessee has developed the land for residential purposes, farm of perennial crops, commercial or industrial property on the land. Simplicity. What you are trying to say is that when you give your land to an indigent of a place without a renewal clause, that is it. Without a renewal clause, without a renewal clause, then the land is subject to automatic renewal. If only the indigent has developed the place for residential purpose. That means the indigent has built a house, or that's where the indigent sleeps, or has developed a place for perennial crops or commercial or industrial property on the land. So it is very, very, very important that you put in renewal clause or something like that. I hope you are getting it. So that is how it is. That is the principle. The principle is that if you give it to an indigent and you don't put in renewal clause, you don't put in anything like renewal clause that, oh, I won't renew it again, or I will renew it. If you don't put in any renewal clause, then automatically, if the person is an indigent, this part will apply. The duration of this automatic renewal is the same as the original lease. So someone will ask, okay, well, if you are saying it's subject to automatic renewal, then for how long? For how long? It is the same as the other one. Hey, very dangerous. So if you took the first one for 50 years, and then there is no renewal clause, and the person is indigent, then it's subject to automatic renewal for additional 50 years. Wow. Wow. Now, the second one is bare land leased to non-indigents. Leased to non-indigents, but they are citizens of Ghana. It's been leased to non-indigents, but they are citizens of Ghana. Non-indigents, but they are citizens of Ghana. So we are saying that unless otherwise specifically indicated in a lease, when bare land is leased to a citizen of Ghana who is not an indigent, the person is not an indigent of the area where the land is situated, the land mandatorily implies a term in the lease that the lessee is entitled to a renewal of the lease. Non-indigent, you are giving the land to non-indigent. You didn't put in a renewal clause. That one also is subjected to a renewal, is subjected to a term, subjected to a renewal. The law mandatorily implies a term in the lease that the lessee is entitled to a renewal of the the lease. So it means that the law says that by force, if the person is not an indigent, put that clause in it, whether you are going to renew it or you are not going to renew it, subject to section 50. Section 50 says that unless otherwise expressly provided in the lease, where bare land is leased to a citizen of Ghana who is not an indigent of the area where the land is situated, there shall be an implied term in the lease that the lease is entitled to a renewal of the lease. So if the person is non-indigent, you must state it, whether you are going to renew it or you are not going to renew it. It is a must. So that one, renewal clauses, it is a must. It is a must for you to state that. Looking at us being on the third point signifies that we have few minutes to end our discussion. Because there are four. The third point talks about leases of bare public land to citizens by the state. Leases of bare public land, public land to citizens by the state. If you're leasing out public land, to citizens by the state is the one that is leasing out the public land. The state is the one that is leasing out the public land. So you're saying that where there is a lease of bare public land by the state to a citizen of Ghana, it is subject to automatic renewal on terms agreed between the parties, except where the lease is in respect of commercial property or the leased property is required for development. So what we are trying to say is that where there is a lease of bare public land by the state to a citizen of Ghana, that land is subject to automatic renewal on terms agreed between the parties. I think it is very, very, very laudable. It is very, very clear. It is very, 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 very clear. So that is how it is. Now we will look at the final part, which is leases to non-Ghanaians by Ghanaians. Leases to non-Ghanaians by Ghanaians. Leases to non-Ghanaians. Leases to non-Ghanaians by Ghanaians. What we are trying to say is that if there is a lease to non-Ghanaians, is it that where the lease is granted by a Ghanaian to a non-Ghanaian, the lessee is not subject to a renewal. The lessee, if you are giving to non-Ghanaian, the person is not subject to a renewal. If you are giving to non-Ghanaian, you can't come and be Ajimai. No, you can't be Ajimai. The land belongs to Ghana. If it is not subject to renewal, once it expires, leave and go, unless the lease expressly provides as such. So the lease must express expressly provide that, oh, it's subject to renewal. If not, the person must leave and go. So where the non-indigents decide to exercise the option to renew the lease upon expiry, it is subject to the terms agreed upon by the parties. So that is how it is. That is how it is. All right. So we are saying that when there is failure to agree on terms for a renewal of a lease, a situation at which there is a failure to agree on terms for a renewal of leases. So we are saying that Act 1036 anticipates that there should be disagreement between lessor and lessee with regard to new terms that would govern the renewal of the lease upon expiry. So automatically, that is how it is. That is how it is. So we are saying the Act makes provision for two main ways of resolving such disagreement between the parties. So we are saying that where the law provides an exceptional case like, sorry, how should I put it? Oh, the Act says that before you can renew it as a non-Ghanaian, there must be an express terms. There must be an express term. Now, the next one says that what if there's an express terms, but the party is not willing to listen to you at all? If that be the case, if you want renewal, but the person says, no, I won't give you. You want renewal, the person says, no, there's dispute. There's dispute under customary. Forgive me. Hello, are you here?
Yes, sir.
Hello.
Yeah, we are together.
Okay. The law says that if you are giving it before you can give it out to a non-Ghanaian, there should be an express terms in the clause. Now, the situation whereby there is no express terms, but the person wants the thing again. Possibly the person has built something on it. The person wants the thing again. You are saying, no, you won't give it to the person. There's a disagreement. The Land Act. These are also some of the changes that the Land Act has made. It has provided a way for the settlement of dispute under leases. So don't forget, it has provided an approach for the settlement of disputes under leases. So Act 1036 anticipates that there could be a disagreement between a lessor and a lessee with regard to new terms that will govern the renewal of the lease upon expiry. The Act makes provision for two main ways of resolving such disagreements between the parties. The number one is alternative dispute resolution, number ADR. Number two is by court. So simplicity, what have we done so far? We have looked at renewal of leases. And then under the renewal of leases, we said that, well, we are going to use what is called PIN. We are going to use what is called PIN. And then the PIN itself help us to get to know leases of bare public land to citizens by the state. So if public lands are being leased out to citizens by the state, what is the principle? The principle is that, yes, it will be, if there is no renewal clause, it is subject to automatic renewal. Bare lands leased to indigents. What is the principle? The principle is that if there is no renewal clause, it shall be subject to automatic renewal. The third one is bear land leased to non-indigenous citizens of Ghana. That one, what's the principle? The principle says that the people or the parties who will be entering into it must mandatorily, it is a mandate for them to put it in it. If they don't do it, that one also, if they don't, okay, non-indigenous, yeah, sure, they are supposed to put it in it. If they don't put it, if they don't put it in it, then it shall be subject to automatic renewal. Automatic renewal. Then we go to leases by Ghanaians to non-Ghanaians. Leases by Ghanaians to non-Ghanaians. It is not subject to automatic renewal. The situation whereby the person says, the Ghanaian says that I'm no longer going to give it to you, and then the person also wants it. Probably he has a lot of property on it. The law says that if there is any disagreement or dispute, it shall be settled with A, alternative dispute resolution, and B, by court. Without much ado, my name is Possible, and I have been your tutor up to now. I wish you the best in your exams. Good luck. Thank you for choosing me. And let us meet again, God willing, next semester. Next semester, I'm hoping to be available so that my contact is this 0548 53 72 58 0548 0548 53 72 58. That is my contact. Save it. Call me. And then let us talk a lot. Next semester, we'll be having our law class. As soon as you are done with this one, we are starting second semester class. If you are willing to be part of it, then you join. You let us get to know, and then we talk. Thank you for choosing me. All right. If you have any question, the door and the floor is open for you to ask your question. Please say hi to me when I mention your name. Abigail Akufu, say hi to me. Mr. Ahmed, say hi to me. Ama Okulu, say hi to me. Mr. Eugene, say hi to me. Please, I can't hear you.